Good afternoon, everybody. I hope you can see me, you can hear me. If yes, can you just type yes in the chat box so at least I know, technically everything is good and fine to go. So if you can hear me, you can see me, you can see the slides, just type a yes in the comment box. Okay, good. So thanks for joining us today. In today's session, we are going to touch briefly, or shall I say, we're going to go through the amendments to the Employment Act 1955, which was recently gazetted, which will go live on 1st of September 2022, in a couple of weeks' time. So we are supposed to have a special guest today. Unfortunately, the gentleman could not make it, so I'm just going to do it alone. And I think some of you all may have known me, or you know me. So I'm going to run through these amendments that we have made. So let me just give you a little bit of background as to why are we organizing this session. So those of you who are members of the forum, members of the Malaysia HR Forum, many of you all have written into us asking for a quick webinar or a short webinar on what exactly are the changes that is taking place, because many members are not able to understand fully what these amendments are all about. So we have got a lot of requests from members, and we thought, okay, why not we just do a webinar to share on the changes, as well as to answer some of the possible Q&A that you may have. So this is a session today. Now, what we would like you to do is, as you listen to what we are going to share over the next hour or two, in case if you have any questions, please post your questions in the chat box, and we will then reply you, either halfway through the briefing or at the later part of the session today. So we will take roughly about an hour and a half to 2 hours, plus minus, but we can go on further if there's more Q&A. Otherwise, we may end it earlier than 5 p.m. Why we put 5 p.m? Just in case if there's a lot of Q&A from members and we need more time. So in case if you have, then let us know. Okay. So let me just go through very briefly a short disclaimer. So today we are sharing whatever we're going to share in the next hour or two is for educational and information purposes only. And what we have done is we have collated to the best of our abilities the information pertaining to the amendments. And we'll share these slides with you later. So once the session is over, these slides will be made available in the HR Forum page in Facebook, as well as an email will be sent out to whoever signed in today. We'll send you a copy of this. So let me just run through briefly. So we know that the amendments to the Employment Act, which is gazetted this year, obtained royal assent on 26th of April 2022. It was published in the Gazette on 10th of May, and the ministerial order was made that enforcement will come into place on 1st September 2022. So, so that is where things are at this moment. And also quite recently, the minister also announced the revision to the first schedule, which will be announced on 1st September. So we need to wait for that as well. So I'm going to jump in to all the various changes. So I've made it a little bit in an easier readable format. But for those of you who are seeing it for the very first time, it may be a little bit confusing. So listen to me, just pay a little bit attention, and I'll try my level best to make things easier for you to understand. I'll highlight all the important ones. So roughly we have got about 30 slides, and I've covered almost all the pertinent aspects of the changes of the amendments, right? Okay, so let me get started. The first is the Apprentice Contract. So you'll see here, you can see current and new. So in some cases, it's only current because the current has been deleted. And in some cases, you'll see current and new. And you also see in some cases new. That means there's nothing to do with current. The government has added on something new for organizations to take note of. So the Apprentice Contract in the past or in current EA, it says that it shall not be less than 2 years. So the changes that has been made, it says it shall be for a minimum of 2 years, minimum period of 6 months and a maximum period of 24 months. So that means previously it says that the Apprentice Contract shall not less be 2 years. It has got to be 2 years or more, but now it is minimum 6 months, maximum 24 months. So what is the uniqueness of this Apprentice Contract? So Apprentice Contract that is defined in Employment Act is excluded from section 10 to 16. Now, 10 to 16 does not apply to apprentice contract. And what are the key contents of section 10 to 16? It talks about the termination provisions mainly. There's also a few others. So it talks about termination provision. And second, it says that apprentice contract only applies if it has been approved by Director General. So if you have your own version of apprentice contract, but you don't get it approved by DG, then it may not be recognized as an apprentice contract. So I think this is something that many organizations do not know. So it's good to get it checked. Do check with the nearest labor office to get a further and deeper understanding on the apprentice contract. The other significant change is the label domestic servant, foreign domestic servant. Now it is called employee to make this more relevant. Servant is a very old term, so now it's called domestic employee or foreign domestic employee. And another change that has been made under section, as you can see here, 69B, C 73, or subsection 81D4, where if anyone is dissatisfied with the decision or order made, they can, within 14 days of such decision or order being made, communicated to him, they can appeal in writing to the DG. So these 14 days has been 21 days. So in case if anyone is not happy with the decision made by the DG, they can put in appeal in writing within 21 days. And there is a new section added, which is section 18A4. And this section is added after the current section 18 on wage period. So this is, in my view, I think many of you all are already practicing it. But in case if you are unfamiliar with, this formula is something new, but I believe most organizations are already practicing it. Yes, we will share the slides in the forum page, and you also get a copy of the email later. So what it says is, how do we calculate wages for incomplete month's work? So in the past, there was some question. I remember many members asked questions. How do I complete? If the employee joined on the 1st and left on the 15th, or joined on the 3rd and left on, let's say, the 20th, how do we calculate that? So what section 18A says, so this new section, what it says is, employee who is employed on a monthly rate of pay, that means he's on a monthly salary, and has not completed the whole entire month, where he started work on the 1st, or his employment was terminated before the month end. Typically, we calculate salary from the 1st of the month until end of the month. If it's 30th, it's 30th. If it's 31st, it's 31st. So we calculate from 1st to 30th, or maybe 1st to 31st. So here, if he commenced employment on the 1st day, and his employment was terminated before end of the month, or where he took leave of absence without pay for 1 or more days of the month, or he took leave of absence because of national service, and so on. So the formula that we apply is this: monthly wages divided by number of days in the particular wage period times number of days eligible in the wage period. So I just give a very simple explanation. If the employee joined us on 1st of June and left the company on 21st of June, so how do we calculate? Monthly wages, let's say his salary is 4,000 ringgit. Okay, maybe salary is 1,500. So it's going to be 1,500 divided by 30 days, because June has 30 days, times he left on the 14th, so times 14. So that's how, and you get the wages for the period from 1st to 14th, the days that he has worked. So that's all. It's actually quite simple, quite straightforward. Many of you all have been using this formula all this while. So I think what the government has done, or what the ministry has done, is to make clear this is a formula to apply, so that no ambiguity, no different definition, and so on. And in section 22, bracket 2, on limitation of advance for employees, the term spouse has been added. So in the previous, or shall I say in current Employment Act, it only covers employees' parents, children, siblings, or any other person under the employee's guardianship. So now we have added the term spouse has been added. Wages in the past, it is said must be paid through the bank, but now the new definition of financial institution. Why? I believe because the financial institution or the banks today have expanded. We've got digital bank, conventional bank, and so on. So that is one. And part 6, principals, contractors, and contractors for laborers. The government has now added in subcontractors. So now it covers principals, contractors, subcontractors, and contractors for labor. Now, here under section 33A, where companies are required to provide information relating to supply of employees, and this is under section 33A, number one, you can see the fine at the bottom. Any company who do not notify the Labour Department or the Director General as required under section 33A would have committed an offence, and if they are convicted and they are guilty, the liability, the fine is will not exceed 10,000. This is in the past, but moving forward, 1st September onwards, the fine has been enhanced to 50,000. So in many of the subsequent slides, you will notice that the fines has been enhanced from 10,000 to, that means it is now increased, so it's more. So in short, if you do not know what is this section all about, I think it's fine. Just don't do it. Follow what the law says. And what has been also added is you can see here in bold, what has been added under section 33A is anyone, a contractor for labor, that means somebody who supplies you laborers, a contractor for labor who fails to make such contract or any document relating to such contract available for inspection as required under subsection 1A, or, and what is added here is N, fail to keep etc., also commits an offence, and the fine is 50,000. So in short, under this section, if the company do not follow what it says, the fine is now 50,000. Under part VIII, employment of women, prohibition of night work, this has been repealed. Under maternity protection, the new label is pregnancy and maternity. And a new paragraph has been added under the current maternity protection, or under part IX, where a female employee is entitled to maternity leave under subparagraph A1, whether or not she is entitled to receive maternity allowance from her employer for the eligible period under paragraph C, or whether or not she has fulfilled the conditions set out in paragraph 2A, she may, with the consent of her employer, commence work at any time during the eligible period if she is certified fit to resume work by a medical practitioner. So in this case, if what it says, the employee is able to start work earlier and she wants to start work earlier, and the doctor has certified her fit to work, she can come back. And I think many of you already know that the maternity leave has been increased from 60 days to 98 days. So if you ask why 98 days, this is quite in line with what ILO is trying to say, which is 14 weeks. So 14 weeks times 7 days, that is 98 days. So Malaysia is moving, an inch closer now to the international practice. And let me move on. So new section 41A, this is payment of allowance to nominee. So the principal act, that means the act that you see today, has been amended by inserting after section 41. So section 41, the new section is 41A, payment of allowance to nominee. So what has been added is this: where a female employee is pregnant or suffering from an illness arising out of her pregnancy, it shall be an offence for her employer to terminate her services or give her notice of termination, except on the grounds of ABC. So what it simply says here, if a female employee is pregnant or is suffering from an illness due to her pregnancy, a company cannot terminate her except if A, there is a willful breach. This employee breaks the contract under subsection 13.2, there's a misconduct under subsection 14.1, or if there's a closure of business. So only these three reasons, company may terminate her, otherwise cannot. And where the service of a female employee under subsection 1 is terminated, then the burden to prove why the termination takes place is on the employer. So employer will need to explain why this employee was terminated. Section 42, there's a label change, restriction on dismissal of female employee after eligible period. So the dismissal has now become termination. And in the past, the maternity clause also applies to all female employees, irrespective of the wages. So, But now we also know that the minister is making some change to the first schedule. So my advice is to wait for the first schedule. So whether or not female who are out of first schedule's label or first schedule definition, whether will they be covered under this maternity protection. So that means those managers, senior managers, executives earning 5,000, 6,000, 8,000, 4,000, in the past they were all covered. So whether they will still enjoy these 98 days, let's wait for the first schedule to be announced formally by the minister on 1st of September. Okay. Now, you may ask, what exactly is first schedule? So this is the current first schedule, and the minister has already made announcement that this will be revised and the announcement will be made on 1st September 2022. So what it simply says under the current first schedule, any person, irrespective of what they do, what is his or her occupation, who has entered a contract of service with the employer, and their wages does not exceed 2,000 ringgit in a month, they fall under Employment Act 1955. That's what first category. Second category is a person who's engaged in manual labor, including labor such as an artisan or apprentice, provided that the manual part, it's he performs majority part of his work hours, or if he's engaged in operation or maintenance of any mechanically propelled vehicle operated for the transport of passenger or goods. Number three, he supervises or oversees other employees who are engaged in manual labor by the same employer in and throughout the performance of their work. That means this person is supervising them throughout the entire work. And the other category is he's engaged in any vessel, capacity in any vessel registered in Malaysia. And five is he is engaged as a domestic servant, those people who are working as pembantu rumah. So this is current first schedule. So the government has said that revision is being looked into. So let's wait for 1st September 2022. So at this moment, it's just for our information, what is going to happen next. So domestic servants, now it's called domestic employee. And again, here under this part, an employer, who contravenes subsection 1 commits an offence and on conviction shall be liable to a fine not exceeding 10,000. So moving forward, the fine has been enhanced to 50,000 ringgit. And under section 57B, so here the duty to inform the DG, Labour DG, on termination of service of foreign domestic servant. Again, if an offence has been committed, the fine shall not exceed 10,000. Moving forward, the fine shall not exceed 50,000 ringgit. So, and like as I said, in many aspects, the fines has been enhanced. So how to avoid it? Follow what the changes are, follow what Employment Act says. Now, under the work hours, section 60A, the labor hours of work has been revised to hours of work and working at night. And I think all of you are already well aware, the basic hours of 48 has now been reduced to 45 hours. And what it also says here, under the section 6 here, the minister may make regulations for the purpose of calculating payment due for overtime to an employee on piece rates and prescribing matters relating to working at night. So this has been added, the sentence in bold has been added to the current clause. So in short, the minister, he can also make recommendation or make regulations pertaining to work at night. And for those employees who are under shift work, under section 60C, what it says is, an employee who's engaged under contract of service in shift may be required by his employer to work more than 8 hours in any one day or more than 48 hours in any 1 week. But the average hours for over any period of 3 weeks or over a period of 3 weeks, exceeding 3 weeks, as may be approved by the Director General, shall not exceed 48 hours per week. So that 48 hours for shift work also has been reduced to 45 hours. Okay, so I just picked one question from Charmaine. 45 hours include lunchtime? No, 45 hours is the basic hours. Lunchtime is always excluded. And another subsection is included, 2A. The minister may make regulations relating to entitlement of allowances during shift work. So this is something new added. Now, if you ask me why is this added, etc., I have my own theory, but I think it's good to, let's just follow through and let's wait for, future announcement by government why this was made, etc. Okay, but I think what is important to note is, you will notice in the subsequent slides that the requirement to work at night shift has been abolished for females and so on. Under section 60F, which is sick leave, so this is another, a big ticket item. What happens is, I'm just going to summarize this slide so it's easy for everyone to understand. Yeah. So currently, the sick leave entitlement for employees is 14 days if they are below 2 years of service, 18 days for those employees who are between 2 years and 5 years of service, and 22 days for those above 5 years of service. So moving forward, the 14, 18, 22 still remains the same. Currently today, we also know that the hospitalization leave total is 60 days. But this 60 days includes the 14, 18, 22 days. So moving forward, because this provision has been deleted, so moving forward, the sick leave is a separate entitlement and hospitalization leave is a separate entitlement. So this is something to take note of. And we also have heard that the paternity leave has been now introduced. So the paternity leave, it's a new section 60FA. What it says is, the male employee, when his partner delivers, he shall be entitled to 7 consecutive days of each confinement. So that means every one delivery or one confinement, the male employee will enjoy 7 consecutive days of paternity leave. However, this is restricted to only 5 confinements, irrespective the number of spouses. So if he has more than one spouse, the total confinement provided, the leave provided is only 5. So what it says here is, a married male employee shall be entitled to paternity leave from his employer if A, has been employed by the same employer at least 12 months. So there's a criteria. So it's not a free flow. Number one, he must be employed by the same employer for at least 12 months, immediately before the commencement of such paternity leave. And B, he has notified his employer of the pregnancy of his spouse at least 30 days from the expected confinement or as early as possible. So this is what it says. Now, so Nor Masura asks, is this applicable for government sector? Now, Employment Act is only for private sector. So government sector, we need to look at different set of laws. Okay, Part XIIB on employment of foreign employees. So the current section 60K has been substituted with the new section 60K. This is about the duty to furnish information and returns. So I'm not going to read the whole entire paragraph. I'm just going to read what has been added. So what has been added is bold. Now, so you can see here under the substituted section 60K, you can see here subsection 1, 2, 3, 4. So under this subsection 4, what has been added is, if the Director General may, subject to any written law, approve an application under this section if the employer complies with the following conditions. Number 1, A, the employer is satisfied with the DGs on the date of the application that he makes. Number 1, he has no outstanding matter relating to any decision or directive or any order issued under this Act. Number 2, he has no outstanding matter or case relating to any conviction under the offence of this Act, the Employees Social Security Act, or the Employees Minimum Standards of Housing Act 446, or even the National Wages Consultative Act. Okay, so that not an issue there. So what it says here is, and also Part B, the employer has not been convicted of any offence under any written law in relation to anti-trafficking in persons and forced labor. So under this section, if any employer were to contravene subsection 1, he commits an offense, and if found guilty, he shall not, the fine shall not exceed 100,000 ringgit, or to be imprisoned for a term not exceeding 5 years or both. Okay, so please furnish on time all the data required. And a new section 60KA has also been added. So what is this section 60KA? This talks about termination of employment of foreign employee. So here it says, if the service of a foreign employee is terminated, so when you hire a foreign worker, if you terminate the service by his employer, that means the employer is terminated service, or if the employment pass issued by the immigration department expires, or C, by reason of repatriation or deportation of the foreign employee, the employer within 30 days of the termination of service must inform the labor DG, and in the way that has been determined by the Director General. And the other condition or the other term is, if a foreign employee terminates his service or absconds from his place of employment, the employer is required within 14 days of termination of service or after the foreign employee's absence, inform the Director General in the manner as may be determined by the Director General. Okay. So so let me see. Let me move on. I think there's a lot of questions here, so let me answer the questions one by one once I'm done with the slides. Okay. Now, section 60L has been deleted. So what is section 60L? Here is where Director General may inquire into complaint. So this has been deleted. So I move on. So new part XIIC on flexible working arrangement. Sorry, the typo T is missing. So flexible working arrangement. So here is a new clause altogether. And what it says is, subject to part XII or anything contained in the contract of service, an employee may apply to an employer for a flexible work arrangement to vary the hours of work, days of work, or place of work in relation to his employment. So it means that an employee, that means your employee, may apply to you as a company or as an employer to have a flexi work arrangement. The hours of work may change, or the days of work may change, or the place of work may change. Okay. And number two, if there is a union in place, there's a collective agreement, any application made by the employer under subsection 1 shall follow whatever terms and condition that is captured in the collective agreement. So this is for companies with union. And the application for flexi work arrangement, section 60Q, what it says is, number 1, the employee shall make an application for flexible work arrangement under this section in writing and in the form and manner that may be determined by the Director General. Number 2, once the employer has made this application, so upon the application made under subsection 1, the employer shall, within 60 days from the date of such application received from the employee, either approve it or refuse it. That means you approve it or you decline or reject. And the employer shall inform the employee in writing why his application is approved or refused under subsection 1, and some reason must be given, and the employer shall state the ground of such refusal. That means it is a requirement for the employer, if you reject the application, you must explain to the employee why his or her application rejected. Okay, now under part XV, complaints and inquiries. So here the word principle has been added. So I think this is also in relation to what we heard just now. So what it says here, I read this, and this is something I think many of us may not be aware of. Section 69(2), it says, the powers of the Director General under subsection 1 shall include the power to hear and decide in accordance with any procedure laid down in this part, if there's any claim by a contractor for labor against a principal, So if you have a contractor who supplies you labor, if he or she has any claim against you as a principal, or a contractor or a subcontractor for any sum that is due to him. So this is under section 69(2). Now, any person who failed to comply with any decision or order made by the Director General under this section commits an offence. So if a claim has been made, it goes to the DG and the Director General makes a decision, and if this decision is not followed, then the defaulting party can be fined not exceeding 50,000 ringgit. So you can see in the past is 10,000, now it has been enhanced to 50,000. And a daily fine not exceeding 1,000 ringgit. In the past was 100, now it has been enhanced 10 times to 1,000 ringgit for every day, as long as the offence continues after the conviction. And so section 69B, 69C, 69D, 69E, all has been deleted. So I know it's going to be difficult for some of you all because you may not be very familiar with these sections. So what is section 69B? It is about additional powers, granted to Director General, the Labour DG, to inquire into complaints. Section 69C talks about claims for indemnity for termination of contract without notice. Section 69D is about order of Director General that may be made in writing. Section 69E is penalty for offence. So all this has been deleted. Okay. And just to note that under section 69B, it provides the power to the Director General, to extend paragraph 69(1)(a) to those employees whose salary exceed 2,000 but below 5. Now, this is where there's a dispute on wages. In the past, these employees could go to Labour Department, even though they're not covered under Employment Act, if there's a dispute in wages. But now this has been deleted. If you ask me, so where do they go to? I would say, please wait for the revision of the first schedule to see who will be included and who will be excluded. So let's wait. But at least for now, just take note of this. Okay, so good question. Joanne asked this question. If section 69C has been deleted, how are we going to claim short notice? Good question. What I can only say based on the amendments, this has been deleted. Okay, new section 69F, discrimination in employment. So what it says here, this is a new section. What it says here is the Director General may inquire into and decide any dispute between an employee and his employer in respect of any matters relating to discrimination in employment. And the Director General may pursue such a decision, pursuant to such decision, make an order. An employee who failed to comply with the order issued by the Director General under this subsection commits an offence, and if convicted, shall be liable to a fine not exceeding 50,000 ringgit. So following all the other changes, the fine has also been set at 50,000, not exceeding. That means it can be low, but it will not exceed 50,000. Okay, and under Part XVA, fine not exceeding 10,000 has also been enhanced to fine not exceeding 50,000. And under sexual harassment, so this subsection 81G has been deleted. Section 81G has been deleted. So here it says that the sexual harassment that is extended to employees outside of the first schedule, now this has been deleted. And a new section has been included, which is 81H, which is notice on sexual harassment, which requires an employer at all times exhibit conspicuously at the place of employment a notice to raise awareness on sexual harassment. So employees are now expected or required to exhibit means publish clearly in places in their place of work notices or notice to raise awareness on sexual harassment. So could be posters, could be some sort of educational guide on sexual harassment. So that is expected of you now. And another new section 87A has been included, which is court order for payments due to employee. I think some of you all may have read quite a recent newspaper where the Labour Department wanted to possess the employee's property, if the employer did not or could not pay for the penalty. So what it says here under new section 87A, court order for payments due to employee, where an employer has been convicted of an offence relating to the payment of wages or any other payments payable to an employee under this act, the court before which he is convicted may order the employer to pay any payment due to the employee in relation to that offence. Number two, when employer, if the company fails to comply with the order issued under subsection 1, the court shall, on application of the employee, issue a warrant to levy the employer's property for any payments due under that subsection in the following manner. So in short, if there's a ruling made against the employer needs to pay the employee. If the employee requests for it, if the employee is not paying the employee requests for it through a court order, the court shall issue a warrant to, levy the employee's property. That means to take charge of the employee's property for any payments. In short, lelong lah. Okay, in short, if you ask me, by way of a distress and sale of employee's property, and this shall follow the same procedure of execution under Rules of Court 2012. You may want to check all this up. And the execution shall apply using this mutandis. Okay, so what is it? Please read it up. I'm just sharing with you some brief overview. And so this is interesting. New section 90B has been added. This is on forced labor. So what it says is, any employer who threatens, deceives, or forces an employee to do any activity, service, or work, and prevents that employee from proceeding beyond the place or area where such activity, service, or work is done, commits an offence, and shall on conviction be liable to a fine not exceeding 100,000 ringgit or imprisonment for a term not exceeding 2 years or both. Okay, so what it says here is an employer, meaning a company, who threatens, deceives means cheated lah. Deceives means cheated, or forces an employee to do an activity or service or any work that prevents the worker from proceeding beyond the place of work or area of work, shall commit an offence. So here it does not say foreign worker, any employer. So it says that any employee, it can be a local employee, it can also be a foreign employee. So okay, under part VII has been deleted, which is section 93. So here it says that an employee of a female employee who commits an offence if the employee is employed contrary to section 34, 35, 36. So that is, deleted. So what is deleted? Prohibition of night work is deleted. Prohibition underground work is deleted. Prohibition of employment by the minister is deleted. So 34, 35, 36 has been deleted. Okay, I just picked up one question from Michelle Ng. Is the forced labor standards follow in accordance with the ILO indicators? So again, here it's silent. What we see is only what you see in the screen right now. It only provides this clarity, but whether or not the 11 indicators of ILO will be, applicable here, I think this we need to leave it to the government's interpretation. So it's good to also, check with Labour Department how in sync is this with the ILO indicators. So this is a very broad definition in my view. And section 99A, this is a clause on general penalty. So if there's any other offences that is not covered there, the penalty is this, 10,000, but it has now been enhanced to 50,000 ringgit. Okay, not exceeding 50,000 ringgit. Okay, so, and a new section has been added, a new section 101C, presumption as to who is an employer and who is an employee. So this is something new on, as far as employment is concerned, but I think many of you all who follows all the awards in industrial court or outcome of High Court, Appeal Court, and High Court of Federal Court, you may have come across this to determine who is an employee, who's an employee. The test that is applied to determine who's an employer and who's an employee. So now it provides clarity here. It provides clarity here. So what it says here is who is an employer and who is an employee. So under this amendment, if there is an absence of a written contract of service relating to any category of employee under the first schedule, it is presumed until the contrary is proved that a person is an employee. If number A, where his manner of work is subject to the control or direction of another person, B, where his hours of work are subject to the control or direction of another person, C, where he is provided with tools, materials, or equipment by another person to execute work, D, where his work constitutes an integral part of another person's business, E, where his work is performed solely for the benefit of another person, and F, where payment is made to the worker or to him in return for work done by him at regular intervals, such as a payment, and such payment is a majority part of his income. So I just read this to you. I mean, brief this to you in a layman term, in a term that is easy to understand. Now, if there is no proper written contract or there's no written contract relating to the employee, what it says here is he shall be, we can assume or we can presume that he's an employee unless proven otherwise. So what is the test, or how do we determine that? If his work is controlled by the company or by another person, his work hours is controlled, he's given tools, he's given tools or materials or equipment to do the work. And if his work is a very important part of the company's operations or the business operations, and if he's provided payment at a regular interval, for example, every month is given payment, now this person is deemed to be an employee unless proven otherwise. And on the other hand, who is an employer and employee? So on the other hand is anyone who controls another person, anyone who directs or controls the work hours of a person, anyone who provides tool, materials or equipment to another person to work, or anyone, if the work done by that person is an integral part, is a very important part of his business, and that person is working solely for his benefit, whether or not payment is made by him in return for work done by another person. So then this person shall be deemed as an employer until it is proven otherwise. Okay, so the first mentioned person in subsection 2 includes an agent. It can be an agent, it can be a manager, or factor of first such mentioned person. So this provides clarity. Sometimes I know we tend to be a little bit confused. Who is a contractor? Who is an employee? Sometimes we get confused between contract for service, contract for service, etc. Now, this particular section 101C, in my view, it provides clarity as to who is an employer, who is an employee. Okay, and amendment to section 102. So what has been deleted is subsection B, prescribing the conditions under which female employees may work at night. So we know in the past it says that female workers cannot work at night unless with approval. So therefore, companies will write in, submit the night shift permit to get, night shift to get a permit of approval. So this has been deleted. Now, what currently exists under clause F, prescribing the times which employees shall be entitled to take off from work for meals and which they shall be entitled or required to take off for rest. So this is still existing. And further added is prescribing matters relating to rest day, prescribing matters relating to flexi work arrangements. So this gives the power to Labour DG or the Minister to make further prescription for matters relating to rest day and flexible work arrangement. And last but not least, so this is the last slide, then we'll go to all the long list of questions that you all have. Now, savings and transitional. So what it says here is any complaint or investigation, inquiry, a trial, or if there's a hearing ongoing, proceedings or appeal done, taken or comments under the current act, the Principal Act, before the new date. The new date of enforcement is 1st of September 2022. It shall be dealt with, continued or concluded in accordance with the provisions of the Principal Act that is active today, as though the Principal Act has not been amended. That means whatever that is ongoing now continues as current. And it further says that any application for approval made under subsection 25A2 of the Principal Act, which is pending before the date of coming into operations of this Act. So this Act means this amendment comes into existence on 1st September 2022, shall be dealt in accordance with the provision of the Principal Act as amended. So we'll follow the new new Act, which is on 1st September 2022. So I just wanted to highlight some of these key changes. So would like to go through your questions. So Jackie Ko asked, if the staff labor in mid-July, that means the employer already commenced maternity in mid-July, when does the 90 days start? So we have checked with Labour Department on this, and what they have mentioned, what they have advised, or what they have said, if the employee commenced maternity before 1st September, they are on 60 days. If they commence after the coming of this new Act, then it's 98 days. Okay, so we will share these slides with you. But now let me just go through some of the questions raised by the members. So I've got my colleague to copy out all the questions, and I'm going to answer one by one. I may not be able to answer all the questions because quite a number of questions are also repeated. So I will choose those questions that are unique and so on. But I think what you may want to do is, once you get a copy of these slides, please go through in detail, take up the old Act and look into the amendments made. Try to read for yourself, try to make some notes, try to understand what is the current, what has been deleted, what has been revised, what has been added on, etc. And wherever you're not clear, I think it's always advisable to go to the nearest Labour office and get further clarity from them. Okay, so let me just go through some of these questions. How to calculate unpaid leave? I think unpaid leave, we have discussed this many times in the forum. You divide the calendar days. That means if the wage period is 30 days, you divide 30 days. So let's say the employee did not work 5 days in a month. So 5 divided by 30, June is 30 days. So 5 divided by 30 times by his wages. When do we divide 26? We divide 26 to determine the ordinary rate of pay that is eventually used to determine the OT payout. There's also a question, unpaid leave. Can company calculate it by dividing working days without Saturday, Sunday? This is asked by Lina Shazwani. I think we have to go back to the definition of wage period. So wage period is the number of days from the start of the wage period until the end of wage period. So companies who practice monthly salary on the 1st to the end, then the wage period is first, for example, in the month of June, is 1st until the 30th of June. For those companies who practice, for example, 26th to 25th, then the wage period is 26th to 25th. So in that period, if 30 days, then you divide 30. If it's 31 days, you divide 31. So you can't omit out Saturday, Sunday if those people who are on monthly salary. So if the employer requests the employee to resume work earlier and don't have any certified information from doctor, is it allowed? This was asked. I think my view is this. You can request the employee to come to work, but if the employee refuses to come, because they are entitled to 98 days. So what the new changes says, if the employee wants to come back and they have been certified fit by the doctor to resume work, then you need to receive them. But if they were to, if you were to ask them to come and they don't want to come, I don't think you can do much there. So the reason why the 98 days was given for them to have longer rest, not for you to pressure them to come back to work. Okay, if the staff report to work earlier than her maternity leave ends, do we still pay full maternity allowance? Now, that's a very interesting question by Vicky here. Again, here, it doesn't provide much clarity what happens to the maternity leave. But in my personal view, again, I would like to share some of my personal comments, but I would advise you all to go and seek further clarity from Labour Department, to understand all these questions that you may have. Now, once the employee resumes work, he or she resumes her salary as usual. So you may ask, what is the benefit of this employee coming back earlier than usual? If they're given 98 days, why should they come back earlier than 98 days? So we also did check what is the purpose, etc. Now, some of them may want to resume work because they want to go back, if they're on shift work, they may want to resume their shift allowance. Sometimes when they're on maternity leave, they may forego certain benefits, certain allowances. So when they come back earlier, they can resume these benefits and entitlements. 45 hours, somebody asked just now, Shami asked this, includes lunchtime. 45 hours are basic hours. So for example, today, if the employee works 8 hours per day basic, then 1 hour, most companies, 1 hour is unpaid lunch break. So they work 9 hours in total. But the work hours, the basic hours is still 8 hours times 6 days, that is 48. So moving forward, these 8 hours per day, assuming if they are on 6 days work, the basic hours per day will reduce from 8 hours to 7 hours and a half. That means 7.5 hours. So 7.5 times 6 days is 45 hours. So there's a question asked by June. For the amendments of Employment Act, is it gazetted on 1st September 2022? No, it was gazetted in April, but the enforcement date will take place on 1st September 2022, as per the order made by the minister recently. Okay, Tony Sue asked this. I'm not sure, is this cover for all male employee? So I'm not sure if you're asking for paternity. Yes, of course, it covers any male employee, where his spouse had delivered. Okay, continuous days include Saturday, Sunday. Yes, that is why it's called continuous. Unless they say continuous working days. So here it says continuous days. So Saturday, Sunday is included. Okay, then Sean Lim also asked a question, because those employees who are out of the Employment Act, their salary is above 2,000 ringgit. We know that these changes has been reflected, that these guys are no longer there. Whether Flexi work will apply for those people outside of EA, that means salary above 2,000, my advice is, let's wait for the minister's announcement or the government's announcement on the revision to the first schedule, who will be covered and so on. So let's wait for that. Paternity leave, does it include weekend? So Satya Bama, just to answer you again, it says 7 continuous days. It does not say 7 continuous working days. So I define it as included, Saturday, Sundays included. Yvonne asked this, means, okay, I think she refers to probation because the sequence of question was right under paternity leave by Satya Bama. Means if under probation, they are not entitled, right? So if we go back to the conditions provided for paternity leave, they must have worked with the employer for 12 continuous months, right? So if the probationer, normally a probationer would be on probation for 3 months to 6 months or so. Sometimes if extended, the employee may be there for, let's say, 9 months or so. So if less than 12 months, he or she, he will not be eligible for it. But there are cases of employers where the probation exceeds or extends beyond 12 months. Then let's say if an employee was on probation for 13 months and his wife delivered, I'm of the view he would be entitled to paternity leave. Because why? His service has gone beyond 12 months. Now, we must understand the law does not distinguish probationer and non-probationer because they all enjoy the same rights. If you all have gone back to Employment Act, the basis of Employment Act, it says that a probationer and a confirmed employee, they enjoy the same rights. So here it does not talk about whether it's a confirmed employee or a probationer. Here it says if the male worker has worked more than 12 continuous months with the same employer and his wife delivers, his spouse delivers, he will be entitled to paternity leave. Is a foreign male worker applicable to paternity leave? Okay, now this is a very interesting question, and we debated this a lot. Again, the law did not, it's very silent. It does not say local worker or foreign worker. So in short, yes, it applies for a foreign male worker as well. So you may think that, wow, but this foreign male worker, the wife is in, the wife could be in the home country. Well, the law provides for them because the law does not distinguish or discriminate between local workers and foreign workers. Our EA is unique. It does not discriminate local worker or foreign worker. So whatever is entitled To workers, it entitles to both male and female in some cases, or local workers or foreign workers. Similarly, maternity leave, it also applies to foreign female workers if they are, if they deliver. So that is under Employment Act. But if you look at immigration law condition governing work permit, that's a different law by itself. Okay. So quite a number of repeated questions. So I'm going to skip all of those. Okay, there's a question asked by somebody here. Can I conclude that wages above 2,000 all depends on company's handbook? I think my advice is let's wait for the changes, to the announcement that the minister will make on 1st September, to the revision of the first schedule. First schedule means who is going to be covered under Employment Act. So there's going to be a revision made. I would rather wait for the minister to make an order, so at least we have more clarity who is in and who is not in. Okay. Now, of course, if the government has made the order, it only covers people at this level, for example. Now, for others, yes, you can put into your handbook, and whatever you put in your handbook would be applicable to those people outside of Employment Act. Okay, Jayanti asked this question. Paternity leave is not limited to 5 surviving children like maternity leave. So I think if we go back to the Act, let's go back to the Act. So what it says here, okay, a married male employee shall be entitled to paternity leave from his employer if, you can see here, okay, restricted to 5 confinements, irrespective of number of spouses. So now it is different from the maternity leave for females, because maternity female, it says 5 living child. Here it says 5 confinements. It does not talk about living child. So Jayanti, I hope you understood now. Okay, Ivan asked, the night shift permit is abolished. Well, I did not say the night shift permit is abolished. All I said was the provision to, for prohibition of females to work at night is abolished. In the past, it is not allowed. But if you want to ask female to work, you need to notify Labour Department, seek their permission. Therefore, you get a night shift permit. So now that it has been abolished, therefore you don't need night shift permit anymore. This is how I would define it. Okay, so Henry, you asked the same question as well as Ivan. Okay, Rose Fariza asked this question. Does the FWA flexi work arrangement allow any pay cut due to shortage of working hours and days? So here I would say that the amendment did not provide clarity. What happens if the work hours, because it allows, let me go back to the provision so at least we are clear there. So what it says here, let me just run through the provision. Okay, hold on a second. Okay, anyway, what it says here, okay, yeah, it's here. So what it says here is, the employee may apply to an employer for a flexi work arrangement to vary the hours of work. That means the hours of work may vary. That means there could be some variety to it, or the days of work, or the place of work. Now, if the employee wants to work lesser, that means instead of working 48 hours a week, the employee may want to work, has applied to work only 36 hours a week, for example. Now, I think what Rose Fariza is asking, can the employer cut the pay, right? So I do not know whether pay cut is the right definition to use. I would say that if the employee is applying for shorter work hours, then the salaries shall also commensurate with the hours of work. So even today, there are cases of employee who's working full-time, where the company employee both have agreed, or upon the application of employee to work part-time, the employer has reduced the work hours of part-time. Therefore, the salary will also shall also reflect the new hours of work. So it's not about pay cut, but I'm sure the salary will follow hours of work. It cannot be the case where the employees' hours are less, but they get the same pay, right? Okay, Section 60K also covers expatriate. I would say that it covers any employees who are covered under Employment Act. Normally, expatriate means their salaries are higher. I think it's 5,000 and above. And if they're not manual workers, they're not covered under Employment Act. So answer is no, Zaini. So unless your definition of expatriate is you're talking about foreign workers. So expatriate, what I understood is people who are under DP10, who is professional, who's on a professional visit pass, where their salaries are 5,000 and above. And these are normally white-collar employees or knowledge workers. Okay, there's a question by Nur Afrika. If the employer has already offered flexi working arrangement, does the employer have to practice new amendments too? I think if in my view, if you're already having flexi work hours today, and you already have provisions where employees can apply, you have the whole workflow is there. They can apply, and what happens next, whether they approve, reject. Now, what the changes says that you need to either reject or approve it. So if you already have your provisions, your systematics, I think you're already one step ahead of everybody else. No? If the company, so this is a question by Amy, if the company is practicing flexible work hours, the company is already practicing flexible working hours. Let me see, do the staff need to submit a letter to employer? So again, I think there could be a scenario. Maybe the employee wants a different set of work hours. So he or she is free to submit to you, and it's also for you to either accept it or refuse it. And if you refuse it, you need to explain to the employee why you refuse it. But I think, Amy, I don't see much issues at your place if you're already having it and the employee is okay with it. But you may be prepared. You got to be prepared in case the employee come back to you saying that I want different set of hours of work. For example, your flexi hour could be you can come in as late as 10 o'clock, go back as come in as late as 10 o'clock and go back as early as 6 o'clock. The employee may come back to you, can I come in at 11 and go back at 7? Also may happen, right? So that is where you need to either approve it or refuse it. And if you refuse it, you got to explain to the employee why you refuse it. Okay, there's a question asked by June. How does the 45 hours distribute equally for those 6 days work per week? So today, if they're working 6 days, 48 hours, it's basically 8 hours per day. 8 hours times 6 is 48 hours. Now, 45 hours in 6 days, if you do a bit of a calculation, it comes to 7 hours and 30 minutes per day. Okay, that is to answer June's question. Let me see. Okay, is there an appeal process for employee in law if his or her flexi work request is rejected by the employer? This is asked by �12𝙊𝘾𝙄𝘼𝙇𝙎. So I think what it says here is company need to only do two things, either refuse it or accept it. So there was also no provision provided for the employee to to bring up his case to Labour Office. But again, I would say that employee can bring up his or her case to Labour Office if the application rejected, because anyways, the provision is silently, it does not say can, cannot, yes or no. But I think there's nothing that stops from the employee from bringing it up. But whether he or she is entertained by Labour Office, then that's we need to see that as it comes. Okay. I don't know whether there's any other questions. I've answered quite a number of questions. So Alia, is there any others? Okay, so there's also a couple of questions coming in now. Okay, I got it now. Thank you. Okay, so now on the flexi work application, the amendment said need to submit in the manner prescribed by the DG. So the question asked is, will there be a form or a criteria to follow? Can we have the form or fields to be included in the form if we were to design it ourselves? This is a question asked by Kat. So Kat, we don't have an answer for it. I think it is best that we wait for further announcement because these are all still fresh. We still have a few months to go before, we have got July, August, so we have got roughly 2 months to go before the new amendments takes place. So I think let's wait for, future announcement by Labour Department or JTK. So let's wait for it. So you're right, there could be some criteria because it says that in a manner prescribed by the DG. So let's wait for it if there is a. Okay, the next question by PH Go, how do we calculate ORP? Currently, it's divided by 48 hours per week. In the new amendment, should it be 45? Answer is yes, you divide 45. That means instead of 8 hours, you divide 7.5 hours. Okay, so can we remain the current ORP calculation? Now, I think, okay, what we know in Employment Act says that you can follow any other formula that you want, provided it is not less favorable than what is, than what EA is trying to say. So now, if the denominator is lowered, that means divide 8 and divide 7.5, now the work hours have changed. So when you divide 7.5, the worker would enjoy a higher outcome. The calculation will give you a higher outcome. So in my view, you may need to follow 7.5, otherwise the employees will feel they are being shortchanged. Why? Because simply the basic hours is now 45 and no longer 48. Okay, my staff salary are all over to, my staff salary, it is over 2,000 ringgit. So what is affected? Work hours, paternity, maternity. So this is a question by, I'm not sure who is this, but again, my reply is this. Now, if an employee is currently not covered under Employment Act, based on current first schedule, so today they are not, provisions of EA does not apply to them. But what is going to happen on 1st September 2022? We know that there's going to be some revision made to the first schedule. So we may need to wait until 1st September to see what is the new first schedule, or is there going to be a new first schedule, or what is the new first schedule, who's going to be included, who is not included. So let's wait for it. Then your question will be answered by them. Okay. Okay. So Vignesh asked this question. So meaning Section 87A. Still have to pay until proven guilty. Now here it says that only upon conviction. That means only when you're proven guilty. Vignesh, it says that upon conviction. Upon conviction means what? You have been proven guilty, you're convicted. Okay, let me see. Okay, so is there any other questions? Okay, so there's a question by Cassandra. With the new Section 90B, so Section 90B is on forced labor. How do you see the impact to the internal job transfer process? So most companies, you have in your employment letter, in your handbook, companies, you may be transferred from one entity to another, from one job to another, etc. So will this be deemed as forced labor? In my view, I don't think so. Forced labor has a very broad definition, and this is always against one's free will, against the terms and spirit of their employment contract. So here, when a company wants to relocate somebody from position A to position B, or move them from entity A and entity B, in my view, it has nothing to do with forced labor. Forced labor happens when they are threatened, deceived, or forced to do so. But here, you've already specified in the employment contract, prior to them accepting it, that you may be transferred from from here to here, or etc. So I think it's two different things we're looking at. Okay, should employer follow all the, okay, this is a question by Atika. Should employer follow all the Employment Act? I guess you're looking at all the provisions in the Employment Act, need to include all in the employee handbook. Yes, once this comes into effect, whatever that we have discussed today, plus the existing ones that is being retained, plus the new ones that we discussed today, you have to follow. In short, this will come into effect 1st September. So 1st September onwards, like it or not, these are the laws of Malaysia as with regards to employment provisions under Employment Act. As a company, we need to follow. So this should also be reflected into your company policy and company handbook. So we know that a lot of questions are asked, do I need to revise my employment handbook? Or do I need to revise the company policy? For sure, those policies and provisions that relates to changes that is happening or going to happen, you got to update it. For example, the work hours, you cannot mention 48 hours anymore. Now it has got to be revised to 45 hours. The provision for sick leave and hospitalization leave. Previously, we said, it's, in aggregate of 60. Now, this has got to be separated. So all these changes need to be reflected in your handbook and also in your employment contract for newcoming employees. For your existing employees, you may need to work on an addendum. That means you need to give them an addendum to say that these are all the changes to your employment terms as required by Employment Act. Okay, there's a question by Fadli here. If under Section 90B, again on forced labor, a foreign employee was promised to perform a job, but when he arrived in Malaysia, he was asked to do another job. Does this apply? So firstly, what I understand on ILO indicators, if I look at ILO indicators, this is called deceived, meaning that deceitful employment practices. That means the employee was not given the right information. So he was promised a job as, let's say, as an operator, but in a manufacturing environment. But upon arrival, he was asked to work in plantation. So under the ILO provisions, the forced labor indicators, that is definitely one indicator which is deceitful employment, which is forced labor. Now here it also says this under Section 90B, an employer who threatens or deceives. So here I think you are pointing to deceive. Deceive means cheating somebody, being cheated. So in my view, if this happens, I think this falls under Section 90B forced labor. Because what he was promised and what is being delivered to him is not the same. Employment bond, does it constitute forced labor? So this one is a very grey topic, Yen. You know, I'm not sure whether to answer you yes or no. Now, an employee signs an employment bond voluntarily. So there's a word voluntarily because you can't actually force an employment bond on somebody, right? There's always a purpose to it. There's always a reason why an employee is bonded. And usually that is voluntary. For example, okay, I send you for this training, you go for the training. That is why employment bond in all companies is always signed before they go for training. You cannot deceive the employee, in my view. You cannot deceive the employee, telling the employee, okay, the company is, wants to send you for this new, there's a new process or a new equipment. We want you to go and get yourself trained. And when you come back, you start running this new particular scope. You did not tell him that you're going to be bonded. So upon him coming back from the training, then you issue him an employment bond saying that, okay, now I want to bond you. So I don't think that's the right way to do. That is why most companies, the employment bond is always, provided to the employee before he or she goes for the training. Meaning that you got to tell them upfront that this training is bonded. Okay, so let me see. Deshi Namaha asks for more explanation, examples to, Section 90B on forced labor. Okay, so the thing is this, because Section 90B is quite brief, it doesn't give very detailed specifics as to, in what context, what are the circumstances, what is the criteria and all that. It doesn't give much. But if you want to understand what exactly is forced labor, I would suggest you to join any trainings or webinars on ILO's 11 indicators, because that gives you a very detailed understanding what exactly is forced labor, right? And I think we must also take note that the Malaysian government has ratified the Forced Labor Convention by ILO. So meaning that Malaysia subscribed to all the 11, indicators, meaning that we comply, or shall we say that the Malaysia acknowledges the indicators of forced labor and we don't do it, right? So take note of that. Let me see what other new questions that has come in. Okay, Lynn, I've already answered the question earlier. If you want to transfer an employee to another place of work, could it be considered forced labor? So I've already answered that a while ago. Okay, I'm not sure what is Worry's question. If company policy 3 months notice period for resignation, so I don't really understand this question. Okay, there's another question. If a staff resigns before the notice of delivery, before the employee is, before the employee goes on confinement or delivery, the employee resigns. Would he or she be entitled to maternity leave? Now, we all know that there are 2 criteria for maternity leave. They must have worked 90 days in the last nine months, and they must have worked in the 4 months prior to confinement. Therefore, they qualify. So if they fulfill that, then they entitled for the maternity benefit. Maternity leave is by default. So remember, maternity leave and maternity benefit is two different things. So for example, female employees who deliver more than 5, that means the law only provides for 5 living child. Let's say they deliver child number 7, number 8, they still go on leave for 2 months, but they don't enjoy the maternity benefit, meaning that the 2 months become unpaid leave, not a paid leave. So the paid leave is the maternity benefit. Okay, so let me see. Okay, there's a question by Amina Nora. Will the male employee be entitled to paternity leave if his fourth spouse undergoes confinement on 31st December 2022? So here I would say that, remember what it says, it goes back to how many? If you remember how many how many confinement? Only 5 confinement. So if his fourth spouse, the confinement of his fourth spouse is the 5th confinement or the 4th confinement, yes. But if it's going to be confinement number 6 or 7 for him, then he will not be entitled to the paternity leave. So we need to read both conditions. Okay, let me see. Wow, there's a lot of questions. Okay, just to confirm, 98 days is for 5 surviving children. That criteria remains the same. Yes, 5 surviving children. That 5 surviving children has not been refined, so that still stays. Okay, this is a very interesting question. If the employee has 5 children, he's got a twins plus 3 children. Is this considered 5 confinements? Okay, I really do not answer this. Now, because the twins is considered 1 confinement, I do not know whether it's yeah, I think, yeah, maybe come to think of it, because here they do not say 5 child, they say confinement. So that female spouse, I mean the spouse of his, goes through 1 confinement, but there's 2 child. So I think in my view, I would consider as 1 confinement, but please check out with Labour Department for their definition. If there's a twin or triplets, do we consider as 1 confinement or 3 confinement? I think logically it says 1 confinement because they're only applying for the 98 days one time only, right? Okay, so we already mentioned that the hospitalization leave is 60 days, and it does not include the 14, 18, 22 days of sick leave. Okay, yeah. I'm going to pick some, because some of the questions are quite repeated. Okay, so Suphan asked this question: if an employee apply for flexible work, but the company decline in writing, with reason, can the employee still appeal? Sorry, I think there's nothing wrong from stopping the employee to appeal, just like any other criteria. Employee wants to apply for certain arrangement or certain benefit, or maybe apply for something, company rejects, there's always an appeal process. So if the employee appeals, the company just have to entertain the appeal, again provide yes or no to the employee. So we can't stop appeals. Appeals are appeals. Okay, there's a question asked by Anis. If we have a contract for service, freelance, part-timer contract, do we still need to follow the minimum wage 1,005, or can the service fee below? Now, if it's a contract for service, that is not an employment, right? Employment is contract of, sorry. Yeah, so this is not employment. So a freelancer, a contractor, they are not governed under Employment Act. But part-timer means what? People who work 30% of full-time hours up to 70%. So these are part-timers. So part-timers are still employees. They are still governed under Employment Act. So remember, casual workers are people who work below 30% of a full-time employee. That means if full-time employee is 45, 30% of 45, I think is about 14 point something. They are not under employees category. And the contractors, they're also not employees. Okay, so I'm just going to pick a few last questions, then we call it a day. But I think you can always post these questions in Facebook, in our Facebook page, and I'm sure many members would be more than happy to reply. Let me see. Okay, we already mentioned just now, ORP calculation, you got to use 45 hours and not 48 hours anymore after this. Okay, Andrea Chi asked this question. If our company practice 11 hours, exclude break, and 4 days a week, so we are still covered under the new law of 45 hours per week. So Andrea, first and foremost, if this 11 hours of basic hours, that means 11 hours times 4 is 44 hours. Yes, in terms of compliance, yes, you do not exceed 45 hours. So there's no issues there. But 11 hours per day, because we know that the law already says that, anything spread in excess of 10 hours is overtime. So you may want to, consult labor office whether the practice of 11 hours without paying 1 hour OT is allowed or not. You may want to check out with labor office. So Isabella asked this question: can the company arrange for work hours such as Monday to Friday 8 hours, Saturday 5 hours? Well, as long as you don't exceed 45 hours, you're lucky, because it's safe. Monday to Friday 8 hours, 8 times 5 is 40, and Saturday 5 hours, 45 hours, you're still okay because you're still below 45 hours. Now we must understand this. The intention of government to reduce the work hours from 40 to 45 is to allow employees to go back or to have lesser, to spend lesser time at work. But if, let's say now, if we come out very creative, I got a question the other day from someone, can I extend the lunch hour from 1 hour to 1.5 hours per day? Because why? I need my employee on site at 6 o'clock in the evening because of some work procedure. Now, then there's no cut, we are not cutting the work hours. The total duration the employee spend in the office is still long. And the employer may ask you, I don't need 1.5 hours of rest time. I just need 1 hour. Now you're asking me to stay for 1.5 hours. So that, in my view, may give room for unhappiness and dispute. Okay, let me see. Okay, Peggy asked this question: foreign workers are they expatriate? What I understand is foreign workers, they come under work permit, salary below 2,000, or manual workers. Expatriate come under DP10. It's a different set of approval. And their minimum salary for expatriate in Malaysia, if I remember clearly, is 5,000 ringgit and above. So there are two different categories. So expatriate are not covered under Employment Act. Okay, if a female employee tenders resignation during her maternity leave, can she use the maternity leave to offset her resignation notice? Answer is yes. Because why? That entitlement is given to them, the 2 months. Okay, what if wife give birth in Malaysia and the spouse stationed in Brunei, but he is under the employment of a Malaysian employer, never come back to Malaysia? Is he entitled to paternity leave? So this is a very tricky question to answer, Yi. But if I were to make an attempt to answer this question, I would say that we may need to first examine his employment contract legality. Is the employment contract issued in Malaysia, enforced in Malaysia, even though he's working in Brunei? So if yes, then I would say he's entitled. So to me, I think you need to look into the aspect where his contract is signed. Is it enforced in Malaysia or is it enforced in Brunei? So the way you have asked here is, but employment is under Malaysian employer. True, the employer can be Malaysia, but if the contract is, legalized in Brunei, he's paid in Brunei, the salary is all paid in Brunei, then maybe a different story. But if his contract is issued in Malaysia, salary paid in Malaysia, I think he may qualify for it. So you may want to consult Labour Office on this. But if he's not under Employment Act and the first revision, the first schedule that's going to be announced does not cover him, you're lucky. Okay, so paternity leave under Section 60 FA says that married male. So does it mean if for those people who are unmarried, they won't be entitled? I think I would agree with this because it says married male. Unlike for maternity, it did not say married. Okay, it's silent, but here it says married male. That means they must be married. Okay, I think more or less, there's a lot of repeated questions. Okay, yeah, let me see. I'll just pick maybe one or two more new questions or something unique. Okay, so Siti asked this. These changes is only applicable in Peninsular Malaysia or applicable under Sabah Sarawak as well. This is only for Peninsular Malaysia. Sabah Sarawak, this amendment has not been done for them yet. This amendment is only for Peninsular Malaysia. Let me see. All private company must follow EA. Yes, as long as you have any employees defined as employed under Employment Act, you need to follow starting 1st of September 2022. Okay, SI Lau asked this. Employee are not allowed to work more than 8 hours in a week, in a day, or 45 hours in a week. Now they work 5 days in a week. So can the work hours be 9 hours? So 9 hours times 5 days is 45 hours. You can, but then you may want to ask yourself this question, because if they work 9 hours basic plus 1 hour overtime, you're basically requiring your employees to be in office for 10 hours a day. Is it too long? Does it defeat the purpose of the revision where the government's intention is to reduce work hours? So this is something that you may want to ask and probably consult Labour Office further. But legally speaking, I don't think there's an issue there. OT hours remain 104. Yes, there's no changes made to the OT hours. It is still 104. So now I think, Chin, you asked a very good question here. Maybe what you did not ask is, so now that the daily OT hours, for example, companies who are in a 12-hour shift pattern, 24/7, that means if you're in a rotating shift, 24/7 operations, what is going to happen is the overtime that you provide every day. So today, if they work 8 hours basic, 1 hour break, which is not paid, and 3 hours overtime. So that means there's a fixed OT or a scheduled OT of 3 hours. Moving forward, the fixed OT or the scheduled OT would be 3.5 hours. So your labor cost is going to increase by plus minus about 11%. So in short, if these employees are working 26 hours per day, and let's assume the 4 hours of OT, the entire 4 hours is OT. Now, then it's 26 days times 4 is 104. Now, if the OT is going to be 4.5, now then you may infringe the 104. So you may want to do a bit of calculation, how your OT hours are arranged, and seek Labour Department's advice. How will this affect your operations? Because some companies, they pay 8 hours basic and 4 hours OT, and all the 4 hours are paid as overtime hours. So you may have some challenges there. I suggest do a bit of calculation and seek Labour Department's advice. How would this affect your work hour arrangement? Okay. Okay, let me just okay, must all wages okay, so there's a question asked by Fong. Must all wages paid through bank or financial institution, as some of the workers prefer pay by cash? I think there's a provision that allows you to do so. Please read it. I mean, please read it. There is a provision that allows you to do so at the request of the employee. Okay. So probably I'll just pick one last question. I know we have got some time, but the questions are all repeated. So it makes it a little bit difficult to pick the questions to answer. Okay, so Josie asked this question, and I think it's quite interesting. Is the paternity applicable to legal wives only? So let's look at what it says here. The word legal, the word wife, it's not mentioned here, it's silent. All it says is restricted to 5 confinements, irrespective of the number of spouses. And then here it says that a married male. So how do we define it? A married male. So the male has got to be married. Of course, the spouse should be legal spouse. So this one is something that I think we should seek further clarity from Labour Department, but I think the intention is there, right? The wife should be a legal wife. Okay. So let me see. Okay, if a male employee not covered under Employment Act, paternity leave can be less than 7 days. Yes, because this is for those employees covered under Employment Act, you must provide 7 days. People who are outside of Employment Act, you can provide whatever that you want. But then the question that is going to arise later is, the executive employee who's not covered under Employment Act, he's going to say that it's unfair because people at the lower level, those covered under Employment get 7 days, but I'm an executive or a manager and I only get 2 days. So you need to also ensure that your internal equity is somehow rather balanced. That is why what I know most companies do is they align the practices, whether you're under EA or you're not under EA. Maternity is 60 days. Paternity leave, they may want to maintain seven days. So that is fair and square across board. Otherwise, there will be some unhappiness among your other employees who are not enjoying the 7 days. Okay. Okay, so Angel asked this question. Deleted, the provision in section 69C has been deleted. Does it mean that we cannot claim salary in lieu due to short notice by the resigned employee? So all it says here is, that provision has been taken away, where the Labour Department, usually you can make a complaint and they help to recover. That provision deleted. But on a contractual term, there's nothing that stops you from getting it from the employee. Just that you cannot now go to Labour office and get them to seek their help to do it for you, or seek their help to make this indemnity claim. You can still claim from the employee. It's between you and the employee. Labour office will not interfere after this, or they will not do anything after this with regards to this. Okay, so okay, so I think I will stop here. Quite a number of questions are repeated. Let me see if there's any one last unique question. Okay, so there's a question by SN. If the salary is paid in Singapore and work is done in Malaysia, shall employee follow this EA? So here I would say that the legality of the contract is its salary is paid in Singapore. So if it all depends, in my view, it depends where the contract is drafted, where the contract is enacted. So if it's valid in Singapore, then it follows Singapore law. Unless there's some provisions that says that he or she shall also entitled to certain provisions of Malaysian law. But it's a bit tricky. I would suggest that you seek further advice on legal advice on this. Okay, so I think I'm going to end here because the questions are all quite repeated. And I don't see any other interesting one. Okay, maybe I just pick this one last one from Joanne. Is it considered forced labor if staff is told that it is compulsory to join company CSR activities on weekends or weekday after normal hours of work? Otherwise, it shall be considered as insubordination, therefore misconduct. The employee is doing part-time study on weekends and certain days on weeknight and would like to be excused. So I think we are too worried about this forced labor provision. The forced labor provision is really intended to look into really serious cases where the employee is in a forced labor situation. But here, I would say this is, it's an issue of inconvenience. Employees asked to participate in a CSR activity on a weekend or weekday. Now, the employee may refuse, but the company says if you don't come, that is insubordination. So I go back to the case of 𝙎𝙊𝘾𝙄𝘼𝑇. There's a unique case of 𝙎𝙊𝘾𝙄𝑼, where he refused to follow company's instruction. And what the federal court said was, he must follow, and then, you got to follow what the company is trying to tell you, as long as the legal order or it's a lawful instruction, and then contest it after that. So Joanne, I think this I wouldn't want to comment much, but I would say that the purpose of the Section 90B is not for this kind of issues. This is what my understanding is from my consultations. Okay, so I think I'm going to end here. And if you have any other questions, please ask in the Facebook forum, and we will try our level best to answer. And there are also many other experienced HR practitioners there who like to answer this. Now, maybe a question to some of you all is, do you all require any further training in detail on Employment Act? If yes, just put a yes, then our team can reach out to you. If you want further trainings, and these are some by the way, those of you who are listening now, if you're not a member of the Malaysia HR Forum, please join us in the Malaysia HR Forum. It's a HR community with over 18,000 members, and we discuss a lot of topics, including amendments to employment law. We talk about there's a lot of documentations, policies, guidelines, etc. So please join us in the forum. It's free for anyone who wants to deepen their knowledge and information and skills in HR area. So please join us. At the same time, we are also having trainings in July. We are having a training on employment law and disciplinary management. We're having a training on conducting domestic inquiry in Ipoh, Malacca, Kuala Lumpur, and Johor Bahru, as well as strategy thinking and planning workshop in KL. So in the employment law and disciplinary workshop, we'll cover again the changes to employment law. So please join us there, and we can speak further on these topics. Okay, I think that's all for now. And thank you for joining us. We will create a small Q&A section in the forum. So please ask any question that we could not answer today in the forum, in case you're not clear or there's any other new questions you'd like to ask. Please please ask this in the forum. Okay. So yeah. Okay. Okay. So there's also a question asked: is there a way we can compile all this question answer, do it to FAQ? We will consider, but no promises at this moment. Okay, so thank you for joining us today. I hope we have shared a little bit on, give you a little bit of insights on what are the changes that is coming up. As a responsible HR practitioner, you may want to take this back to your management to tell them that these are the changes coming up. These are the potential impact to the company's operations. There are impact to your operational arrangement. There's going to be impact to also your financial arrangement, because why? For those who are 24-hour shift pattern, or there's going to be a labor cost increase because of the reduction of work hours, where you need to increase your overtime. There's going to be some changes to your workflows. So it's good to bring this back to your management, preempt them that these are changes that is coming up, and start making preparations now itself, while waiting for the effective date, and also while waiting for the minister to make the announcement on the revision to the first schedule on 1st of September. So thank you, and do join us in the Malaysia HR Forum Facebook page. So these slides will be shared in LinkedIn, it'll be shared in Facebook, as well as will be emailed to all of you. Okay, so thank you, and have a good day.